This is the Wisconsin versus Yoder case.
Hey, we're doing the Wisconsin versus Yoder case that took place in 1972. Hi, my name's Ayodele Jackson. I'll be elaborating on the parties and roles of the case, the outcome of the court's decision, and whether we disagree or agree with the court's decision.
Hello, my name is Adonis Caneris. I will be discussing the basic facts surrounding the case, the legal issues related to the religious freedom, as in this case, it dealt with the free exercise clause, and along with how this case has impacted us today and how we see it in our everyday lives.
Here on this slide, I'll be talking about the background of the case. This is a legal case that was brought to the Supreme Court level that involved the state of Wisconsin and an Amish father from Greene County, Wisconsin, who went by the name of Jonas Yoder. He was representing himself and two other fathers who go by the name of Wallace Miller and Aiden Utsi. All three of them had a child that had just finished eighth grade. The Wisconsin was arguing that these parents were violating Wisconsin's compulsory school attendance law. Jonas Yoder was arguing that their argument was invalid because it violated their First Amendment right, which was the free exercise of religion.
So I'm going to discuss on this slide the basic facts that surround this case. So starting out in the state of Wisconsin, they have in place compulsory school attendance laws. If you're not familiar with this is a law that says parents must send their kids to school until the age of 16. They must receive an education until the age of 16. Once they turn 16, they can continue to whether continue the education or go elsewhere and do something else. The three fathers that are involved in this, Jonas Yoder, Wallace Miller, and Aiden Yutzi, ended up pulling their kids out of school after the eighth grade. They refused to send their kids to any public or private high school around them, and they wanted them home with them. And they did this because of their beliefs. They were Amish and Mennonite religious followers, so this is where the issues start to arise. Now, the Wisconsin steps in because the three kids that were pulled out of schooling, two were of the age of 15, the other one was the age 14. So this violated the law of Wisconsin saying that you had to send your kids to school until 16. So this made all three fathers take a trip to court where they were convicted. They were found guilty of violating Wisconsin's compulsory law that was in place, and as a result, they all were going to be fined $5. Obviously, they did not agree with this, but the trial and circuit courts actually upheld these convictions. They told them that the state law was reasonable and it was a constitutional law that was in place. And the three fathers, you're in the wrong for not following this, and you guys have to accept your punishment. However, the Wisconsin Supreme Court steps in and says they found the application of the law to the Amish people, violated the First Amendment free exercise clause of religion. Ultimately, this dispute between the courts is what brings this case to the Supreme Court, where it has to be finally decided by the U.S. Supreme Court. Now I'm going to talk about the legal issues related to religious freedom in this case. And in this particular case, Wisconsin versus Yoder, the issues are mostly related to the free exercise clause that is found in the First Amendment. So the free exercise clause pretty much states that it protects citizens' rights to practice their religion as they please. Uh, but as long as it is not running afoul of public morals or compelling governmental interests. So, as long as they're not going out there and like harming themselves or other people or disrupting any sort of thing for anyone else, you're fine to kind of believe what you believe and practice it how you practice it. So in this case, with Jonas Yoder and the three fathers, who are again they're Amish and Mennonite religious followers. So if you're not really familiar with why the Amish do not send their kids to high school after the eighth grade, it really boils down to two main reasons. And the biggest reason is that the Amish want their kid, and like any parent wants their kid to contribute to their society and their community. But for the Amish, after the eighth grade, those kids are starting to learn a trade that is going to help them offer and contribute something to their community. And this trade is usually there's no public schools or private schools that offer adequate training options for them to get ready for this part of their life. And then the second reason, which is not as big but still factors in, is that the Amish typically have a certain view on high schools and colleges. They view these places as institutions that, offer and kind of go against and promote ideas that are going against their Christian values and beliefs. So, therefore, Jonas Yoder said, hey, my kid and the rest of these kids are not just going home and sitting on their butts and not doing anything. They're working hard because the parents are educating their children. They're educating them at home to in these practical pursuits and prepare them to become functioning adults in their communities and in their way of life. And all high schools do is threaten their Amish way of life if kids aren't getting the chance to prepare themselves for the trade they have to do. And since, the state of Wisconsin could not prove or show that having an educational system law in place was more important than the Amish family's right to freely exercise their right of religion, that's why the case went to the Supreme Court, because they couldn't prove that, you know, this education they were missing out on was more important than the education that the Amish kids were receiving at their house. So this is where the big legal issues comes to play.
Here on this slide, I will be talking about the outcome of the case, which ended up being a unanimous decision in favor of Yoder. The court ruled that the Wisconsin compulsory school attendance law was not applicable to the Amish. They did make it clear that not all belief systems are protected under that clause. If someone had a crazy belief system that severely harmed the children, it would be a different story. But the Amish way of life have been around for about 3 centuries, and nothing has been proven to harm these kids. Douglas said there was no evidence that 2 more years in high school will make these kids any more prepared for the real life or any more of a burden on society. There was partial dissent from William Douglas as he was saying the children should have a voice in this and not just the parents because it is a child's life and not the parent's life. Here on this slide, I'm going to tell you whether if we agree or if we disagree with the court's decision. So we agree with the court's decision. We agree because through eighth grade, you can develop the necessary skills in not only math, but in science, reading, and writing to be able to function in the real world. And the reason as to why I say this is because throughout those first eighth grade years, you learn simple math, simple science, simple English, simple reading, and simple writing. That is enough to get you through a decent part of your life. So, in my opinion, they're not being robbed of an education. Since there is no evidence of this hindering Amish kids as people, it does not endanger the kids. They may be out of high school after eighth grade, but for the next 2 years, their parents educate them to get them ready for their economy and how to adjust to adult. This is, in my opinion, this is great because this gives them the opportunity to live the Amish lifestyle to see if they really want to live the Amish lifestyle and continue with it, or if they want to go back to school and do that with the real world. So, so with that being said, they're learning and training in their trade and acquiring the skills to be successful in their community. And that is the Amish way, and that is if they want to choose the Amish way of living. Therefore, we agree that the court made the right decision in exempting the Amish kids from schools after eighth grade. This is absolutely amazing for them because it really gives the child a choice to follow in their parents' footsteps and to help their parents out, help their family out, but also the choice to say, hey, I like it, but I also want to go do school and finish out my school year and go to college, finish out high school and go to college. So I feel like this is they made the perfect decision, giving the kids a choice whether or not they want to do it or not. Thank you.
So, lastly, to kind of close this presentation off, I'm just going to talk about how this case has impacted us today, how we see it in our everyday life, and how it's acted as a precedent for everything going forward. So, due to this case, the homeschool movement gained a ton of traction because it was often used as the case that defended the right of parents to choose to homeschool their kids. And even though parents still have to prove that even if they're not Amish or they're another religion, that the religion has been established for a while and that it's consistent historically with uh, kids at a certain age doing something else than going to a high school. That stuff still plays a factor, but this case right here was what really helped the homeschool movement kind of take off, and is why a lot of kids are able to get homeschooled today. And then the other thing that this case did, obviously, with a case like this, it set a precedent going forward. In the event that states kind of clash with the free exercise of religion, kind of comes again, the Supreme Court and other courts have something to look at and base it off of. They can compare the situation they're dealing with at hand with this case right here, and how you have the right to free exercise your religion, and it comes to an extent, but it is in place, and this has helped so many people in cases going forward. So thank you for your time, and this was our recap on the Wisconsin versus Yoder case of 1972.